Welcome to This Constitution. My name is Savannah Eccles Johnston.
And I'm Matthew Brogdon.
And today we are going to talk about judicial review, which is the only judicial check that we'll talk about this season, but it's the big one. So first, let's just define what is judicial review so folks know what we're talking about.
Oh, well, the simple definition is a court declares a law unconstitutional. That's what we say, but that doesn't actually tell you what happens.
Right.
And if you compare this like the veto, we know what happens when president vetoes a law. The law doesn't become law. It's not written down with a note next to it in the statute book. But when judges declare a law unconstitutional, they're saying that the law is in effect unenforceable. If you try to prosecute somebody for burning a flag and the court says, well, that violates the First Amendment, so you can't prosecute this person. There's not like a judicial Sharpie that comes out and lines out the flag burning statute in Texas. In fact, the flag burning statute is still on the books in Texas and many other states, even though it can't be enforced, because all judges are doing is saying that law is unconstitutional, so you can't use the courts to enforce it.
And just to clarify, we are talking about acts of Congress and state legislation.
Mm-hmm.
We're talking about both here. We're also talking about acts of the executive. Executive orders can be struck down.
Everything. Almost everything.
Okay, so this is a massive power for the Supreme Court. Where is it in the Constitution?
Oh, well, the easiest place to start in the Constitution is with the one clear mention of judicial review.
Okay.
Like there's one provision in Article 6 in what's called the Supremacy Clause that tells state judges they're supposed to declare state laws and constitutional provisions unconstitutional or declare them void if they conflict with a federal law or the federal Constitution. So there's some complex language here. The Supremacy Clause says this Constitution, hey, good phrase, by the way, this Constitution, all laws made in pursuance thereof, and treaties made by the United States are the supreme law of the land. And then it has this peculiar, like, next phrase, because the suggestion is if it's the supreme law of the land, supreme over what? Like, what if we're going to the bother of saying this is supreme? What's inferior? And so then it continues, and the judges in each state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. So a state law or constitutional provision can't withstand a conflict with federal law, and judges are somehow supposed to give effect to this. So the only clear mandate for judicial review in the Constitution that's just on the face of the text is state judges being commanded to hold these state laws unconstitutional.
See, this is interesting because one of the comments I get online fairly frequently from disgruntled watchers of the Supreme Court is judicial review is unconstitutional. They say, where is it in Article 3 of the U.S. Constitution? The judicial power shall be vested in one Supreme Court and in all other courts, which Congress shall from time to time ordain and establish. And that's it. Yeah. It doesn't say they can do X, Y, or Z. But I think what is missed here is there was an assumption at the Constitutional Convention. There's precedent before the Constitutional Convention, and even the ratification debates, there's mention of judicial review. So it's not like Marbury versus Madison creates the idea of judicial review out of nothing, and now we have a Supreme Court that was not intended to be as powerful as it is.
Yeah, interestingly, Chief Justice Marshall in Marbury, which is the case we always point at as sort of the court's embrace of this idea. It's not the first instance of it, but it's right. The court openly embracing it. Marshall claims it's in the text. He says this phrase in Article 3, Section 2, the judicial power shall extend to all cases arising under this Constitution. Same word used in the Supremacy Clause phrase. And he claims that's a power to resolve disputes about how the Constitution applies to particular instances. So to resolve a case arising under the Constitution has to be to decide what the Constitution means as applied to that case.
Right.
And that was a pretty straightforward line of reasoning. You mentioned like the convention, the ratification debate, some of this other stuff. These are the people who are writing the Constitution and then arguing over whether to adopt it. Judicial review does come up repeatedly. Practically everyone in the debate agrees it exists somewhere and in some form.
Right.
They're debating like exactly when and over what and who should be exercising it. But the fact that it was part of a judicial power under a system with a written constitution that the people had made and that limits government was actually pretty uncontroversial when the Constitution was being written and ratified.
Right. So this is something Alexander Hamilton will talk about in Federalist 78, where he will defend judicial review as a necessary check on legislative power, basically legislative overreach, violation of rights. And this is very interesting. He's comparing the will of the people as expressed in the Constitution and defended by the Supreme Court with the will of representatives, who, of course, are chosen by the people as well. So really what you're talking about is the long-term will of the people and kind of the ancient will of the people being defended against the short-term contemporary will of the people.
Yeah, he sets up an opposition between popular sovereignty and the legislature in a way. And what he's suggesting there is that when we, the people, enact a constitutional provision, we're being sovereign in some way that we're not whenever we vote in a legislative election. Like ordinary elections just don't have the same authority as the processes we use to enact constitutional language. And we, the people, speak really authoritatively with the constitutional language, but we only speak in a sort of moderated form or a less authoritative form when we elect representatives. And so judges have to look at this and go, well, which one of these should I prefer? The will of the people in the legislature, which is kind of a weaker sauce, weaker form of popular sovereignty, or the will of the people expressed in the Constitution? And Hamilton has lots of reasons for wanting to prefer that because he thinks this is more stable. And elections are more, I don't know, what's the word?
Haphazard.
Yeah, a haphazard measure of what the people want.
Well, this is interesting, though, because you actually get kind of a flip on this. By the time you get to like Oliver Wendell Holmes, the idea of the will of the people is embodied in Congress and in their current acts and not in this old Constitution that is only very rarely touched by the people in the amendment process. So we've kind of flipped on which one is a more serious example of popular sovereignty.
I mean, this was actually sort of a dispute between Hamilton and Jefferson. I've been co-teaching a class on Hamilton, Jefferson, and Madison. It's just all their writings, and it's we call it rival founders.
Cool.
I've been co-teaching this with a friend who's visiting here, Brad Wilson. You know, Hamilton and Jefferson, and for that matter, Madison too, is kind of on Hamilton's side with this. There's this Jeffersonian idea of the sort of dead hand of the past. That that a perpetual constitution gets to a certain age and it's sort of aged out. Popular sovereignty is aged out because the generation that passed it's dead and gone. And Hamilton and Madison are both mortified by this view. I mean, they think, gosh, this is so dangerous because this is going to undermine the idea that you have any permanence and stability in law. Jefferson thinks, great, sounds great. Let's hazard the whims of the moment and see what happens.
Right. Well, I think this kind of goes to a core of Jefferson's, I'll call misunderstanding of stable government and good government. In his mind, revolution never ends. In many ways, it's just kind of in lockstep with the French in this in 1800 perspective. But he didn't fight in the Revolutionary War, and he didn't actually have to do a lot of the work of the Constitutional Convention and of these early state periods. And so it's nice for him to come in and say, you know, in some sense, the revolution is perpetual. But if you're Madison and you're Hamilton, you say, whoa, 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 whoa. The hardest thing about revolution is ending it. It's creating stable government. And the way you do that is stability and veneration in the laws.
I'm kind of reminded of that, you know, kids with Lego sets, you know, you always have that child in the family who sort of meticulously constructs the really complex Lego set over the course of days. And then there's the kid who just likes to dump out the bin and do stuff. And they do not mind going over to the, you know, sort of gargantuan pirate ship Lego set and just sort of pulling off pieces at whim. And because for them, they're like, well, just get something else and stick it on there, you know, like what's the big deal? And this is to me sort of like Hamilton and Madison versus Jefferson on this, because they're thinking about building institutions and durability and perpetuity. Like they actually think about the idea of a perpetual system of laws that you don't have to go back and rebuild all the time.
Right.
And Jefferson's idea of democracy is hostile to that notion, this idea that you're just going to inherit your political forms and be content with them. And he really is. I mean, at one point, one of the most shocking things I've seen Jefferson write actually was at one point he's writing a letter to somebody sort of, you know, thinking about this issue of perpetual laws and how it's the dead hand of the past sort of ruling you. And he says, you kind of need, and this might be in the same letter where he has the line about the tree of liberty has to be
continually watered by the blood of patriots.
And tyrants.
And tyrants.
Yeah, you want to make sure the tyrants bleed too. That's really important. But in that same one, he says, but that means you're going to have some pretty rowdy people around. There are going to be some sort of rebellious types, and this is going to break out into these sort of small rebellions. Mm-hmm. And I think he has in mind here, like the Whiskey Rebellion, which happened early on in Washington's administration and other things. And he actually says, these people perform an indispensable role. He says, in fact, their role's so indispensable that they're doing a sort of public service, and they should be, even if they commit crimes in the course of this, they should be pardoned. That a sensible statesman would pardon them for their small rebellions. And I thought, what do you think of January 6th, actually?
Right. Well, and what's interesting is, what would he have thought of Shays' Rebellion leading up to the constitutional event? Right. This event terrifies people into Philadelphia, I guess, into Annapolis, and then into Philadelphia. But maybe he would have seen it as a good thing.
Well, in fact, he tells Madison, I think you guys got carried away. The Shays' Rebellion thing kind of sent you all running for the hills. Maybe it's less of a big deal than you think it is.
Right. But I think he's writing this from France, right?
So how this impinges on judicial review, though, right, is that judges look at a constitution that's inherited. It's old law. In fact, the older it is, the more venerated it is. Right. Now, nobody feels the way about the 22nd Amendment that they do about the First Amendment. Uh-huh. We might have to test that theory at some point in the next couple of years, actually. Okay. When judges are doing this, they're sort of appealing to the idea of like, hey, we all agreed to this a long time ago, and you can't violate the bargain, even if you've sort of changed your mind or you found what you think are exceptions to it. And that's kind of what judicial review is holding people to the original bargain, even if in the moment they want to depart from it. And that really smacks of the dead hand of the past controlling a current majority.
But I do think we need to clarify here. This is another question I get online a lot, is what does this have to do with amendments? So amending the Constitution changes the wording of the Constitution, meaning the Supreme Court can only rule on the Constitution as it's written, and that includes amendments. So an amendment process is a completely valid way to change kind of the old wisdom of the past according to modern preferences. The Supreme Court can't touch that. So we're not talking about the amendment process here. The Supreme Court can't touch this. So let's just get that clarified. Okay, so. And
in fact, we can use amendments to overturn Supreme Court decisions.
And have.
We've done. How would we tabulate these? This has happened at least
many times.
The 11th Amendment.
The 13th Amendment
was overturning it, the 13th Amendment. The 14th, insofar as it had a provision about citizenship. The birthright citizenship provision was overturning Dred Scott versus Sanford's claim that free black people could never be citizens of the United States.
Right.
Which other ones have we got? Income tax?
The income tax is one. We know the 19th one overturns Minor versus Happerstat.
Right. That's kind of an interesting one, because the court goes, well, you didn't clearly say that the 14th Amendment covered women.
Of course.
And, so the court says, we don't really see that in the 14th Amendment. So the 19th Amendment could either be overturning that old one. This is actually an interesting kind of dynamic. You can think of it either as overturning the court's judgment that the political rights of women weren't included in the 14th Amendment, or you could see it as leaving the 14th Amendment as is and sort of adding something totally new. Does the 19th Amendment answer that in any way? Is there anything in it that sort of suggests that it's doing one or the other?
Not that I can think of.
It just sort of does it.
Yeah,
it leaves us to figure out.
Yeah. Yeah. Well, this lends to my general view of history, which is that women always lose. So even with the 14th Amendment, women always lose. So the 19th Amendment is a nice thing. The one time women win.
It's a good point. They're winning in college right now. I think they're beating the boys pretty soundly on earning degrees.
I have my own views on that. I think it's more male flight because women are joining into college institutions.
Oh, that's interesting. Okay.
But anyways,
we
back
do like
to
working outside.
I think you'd like working where women are not. I think that's the key. But anyways, now we're getting sidetracked here. Sorry. So let's get to Marbury versus Madison, which has nothing to do with women. Marbury versus Madison is the first time the court kind of takes this power and says, yeah, actually, we do claim this. even though it's been assumed at the convention, Hamilton has spoken openly about it in Federalist 78, the Judiciary Act of, what was it, 1798? Is that right? 1796?
1789.
Oh, wow, I'm really off. Thank you. 1789.
So one of the first three big things the first Congress does.
Right. Alludes to, or actually just directly grants this power to overturn state laws. So this isn't new by the time you get to Marbury.
In fact, Marbury is the first time the Supreme Court openly exercises the power of judicial review and declares a federal law unconstitutional. There are multiple instances in the 1790s of lower federal courts actually invalidating federal statute. And there are at least two other cases of the court upholding federal statutes, but saying if they were such and such, they would be unconstitutional and we'd have to strike them down. I think it was Ware versus Hilton and Hilton versus United States. And then there's this famous case, United States versus Yale Todd.
Oh, I don't know about this one.
Well, it comes out of a series of cases. Congress told the circuit courts that they had to act as pension boards for Revolutionary War veterans. So the Secretary of War was empowered to provide lifetime pensions for Revolutionary War veterans and their dependents. But you had to figure out, and this was not easy at the time, had the person actually served? Had they actually suffered an injury? Was this person actually a descendant of this person who died? So a lot of facts to figure out here.
Right.
And so what Congress did was they said, well, we do have these circuit courts floating around that sort of meet in each state twice a year. So we'll just have them act as commissioners for the pension system. So you'd go in front of the circuit court and demonstrate you were entitled to it. The circuit court would give you a decision and say, yes, it sounds like you're entitled to this. Now, that sounds like something a court might do. But then their decision would go to the Secretary of War, and the Secretary of War could either grant the pension or overturn it.
Oh.
So this is a very serious problem. You're basically making the court subordinate in this factual determination to a cabinet secretary in the executive branch. And so three separate circuit courts who are asked to do this all hold it unconstitutional. One of them sends a letter to President Washington explaining we won't even hear the cases because this is unconstitutional. Two of them render decisions and refuse. Well, one of them renders a decision and says, we can't decide these cases, and there's actually a judicial opinion that says, can't do this. And then one of them actually says, well, we can't do it as a court, but we'll take off our judge robes and we'll put on our pension commissioner robes and we'll sit as a separate body.
Ah, okay.
So they all thought this is unconstitutional as written by Congress. And somebody actually challenged a guy named Yale Todd, who was somebody who had been denied benefit. Well, I think he'd been granted benefits and then the United States challenged his benefits. Goes to the Supreme Court, and the Supreme Court upholds the decision of the circuit court saying that this was unconstitutional. The problem is we don't have any written opinions in the case. We have a record of oral argument, and we have a decision, an order that says Yale Todd's not entitled to the thing because the pension bill was unconstitutional.
So hence it's Marbury versus Madison that is our
that's
benchmark.
The one where we sort of openly, and this is important, the episodes in judicial review that we remember or that we take note of are typically those that get public notice.
Right.
So actually the history of judicial review, even of acts of Congress, is expansive. There's actually been something like 350 plus instances of Congress doing this. Up until a couple of years ago, we thought that there were only 125.
Right.
And then Keith Whittington, who's at Yale now and was at Princeton, went through every case he could find in the U.S. reports, trying to identify every case where the court had said something about a federal law was unconstitutional. And he actually found 356 instances of it up through 2022. So it's 3 times as many as we thought existed. The difference was we just didn't take notice. Congress didn't even notice whenever the court did this most of the time.
Right.
There's no official system. When the president vetoes a law, he writes a list of objections and sends it to Congress. Congress says, oh, the law's been vetoed. There was no mechanism, never has been an official mechanism in American history by which Congress is notified in any way when a federal law is declared unconstitutional by a court. They just kind of have to, it has to come to their attention somehow, or somebody has to tell them.
But this kind of acts as a double-edged sword for the Supreme Court. Yes, it means they get away with, or not, maybe not get away, but they use this power far more frequently than we think. But the times that we pay attention to it are those extremely controversial political moments. Marbury versus Madison is a deeply political decision. It certainly helps the expansion of the independence of the Supreme Court and thus the Federalist Project long term. But there's other
Can you explain why that is the case? Like, how does it, what's so political about it? Like, it's pretty mundane on its face. Like they said this provision buried away in the Judiciary Act is unconstitutional, saying the court can issue writs of mandamus in original proceedings. That sounds sort of highly technical. How can that be?
Right.
That's not like striking down the Affordable Care Act. You know?
No, that's true.
So why is it such a politically consequential case?
Well, in some ways, it politically benefits the Jeffersonians because now they get to appoint all of these justices because Adams' nominees, including Marbury, haven't been notified. So they don't get to take their seat. So you'd think this is a short-term win for Jefferson. He should be really happy. But what you've just done is declare the long-term independence of the Supreme Court and its power and the power of the Constitution as the actual vehicle of popular sovereignty to thwart temporary political movements. This is
because the Madison and Marbury versus Madison is Jefferson's Secretary of State. So Madison wins. Like, this is the weird thing. The administration won the case.
Yeah, just not long term. The court wins long term.
But they only win. The court says, you only win because we get to say what the Constitution means.
Exactly. Yeah. Well, but there's something kind of brilliant about this is the court is denying itself this tiny little power that really doesn't matter that much and declaring for itself this massive power. And in a way, it's symbolic. The court is stepping in to this checks and balances game with the other two institutions. And from that point on, not to say they weren't before, they have played a significant role in American political history, a political role. You can think of some of our most controversial decisions. The court is not a weak, certainly not the least dangerous branch, as Hamilton seems to think.
Well, Hamilton didn't say it was the weak. Well,
he said it's the least dangerous branch.
By far the least dangerous branch to the political rights of the Constitution. That's what he says. So it's the least likely to destroy your rights, is what he actually says.
The court has played some big roles in American history where it has certainly hampered rights and in other cases expanded them.
Yeah.
What I'm trying to say is judicial review is the basis for the court being a co-equal branch of government. This is what makes them powerful, but it also makes them extremely controversial and potentially problematic in a democratic system. So let's think about some of the most recent cases where the court has brought itself into deep political controversy. You can think about Obergefell v. Hodges, right, which basically legalizes same-sex marriage nationwide. Now, you can ask the question, what does this have to do with the Constitution? Surely this would be a democratic decision that Congress needs to make that big choice for themselves, man up, make the decision. But instead, it's decided by the Supreme Court.
Well, this is an interesting case, too. So Obergefell raises one of these questions, like Congress doesn't have any laws about marriage because the federal government typically doesn't regulate marriage.
So they had previously had laws, the Defense of Marriage Act, DOMA, right, 1996.
To keep states or try to keep the Supreme Court from federalizing gay marriage.
Right.
Yeah, so they're sort of anticipating this sort of thing and going, well, we got to fend this off. And even the Defense of Marriage Act was sort of like, well, this is not our job. It was supposed to make sure that, like whatever states decide about marriage just obtains in that state. They're trying to sort of prevent a nationalization of it. So it's one of those interesting dynamics where the court tackled an issue where Congress was saying, we really don't want a federal policy on this, like pushing it away and going to it, okay, fine. There's going to be gay marriage here and there's going to be gay marriage there, but we don't want it everywhere or we don't want to get involved in this. And the court, as you put it, sort of not just drags itself, but sort of drags the whole federal government into the issue. In a way. So that's one of those, maybe what you're pointing at there is a situation where the court can actually reach out and do things in policy areas with judicial review that even Congress would not normally touch with its regulatory power.
Kind of the nationalizing effect there.
Yeah.
Of the Supreme Court.
And that is pretty significant. That's
deeply significant.
Tremendous. Yeah.
Well, and then let's think about what happens afterwards. So in the wake of the Dobbs v. Jackson decision, I believe Congress went and passed its own law legalizing same-sex marriage nationwide just in case the Supreme Court ever overturns Obergefell. So now it's protected nationally either way.
The Respect for Marriage Act.
Is that what it is?
Yeah.
Yes. It's now thoroughly a federal issue.
The Respect for Marriage Act is as modest a version of nationalized gay marriage as you could conceive.
But more than what existed before Obergefell.
It is, yeah. So the courts forced Congress into a situation where even they're sort of, the court says the Constitution requires marriage equality throughout the country. Dobbs versus Jackson comes along and says, well, which has nothing to do with gay marriage, but rolls back the abortion right. Mm-hmm. So overturns Roe, Planned Parenthood versus Casey.
And sends it back in some sense, back to
to the states.
Right, back
to a situation where every state decides for itself. And people say, ooh, well, what if they do that with Obergefell and gay marriage? And so the Respect for Marriage Act comes back, which I think was crafted in part by some Utah-associated folks, interestingly enough.
Didn't know that.
They helped put this together. The Respect for Marriage Act, gosh, I wish I had reread the statute now, but I remember whenever I read it, I thought, wow, this is a really quite modest provision, because what it actually does is it grounds, I think the only clear protection for gay marriage it actually provides is grounded in the full faith and credit clause. It says that every state has to afford full faith and credit to any marriage that's already been contracted and any marriage performed in another state. Right. So that means a state could, under that provision, go back and stop it. Like if the court overturned Obergefell under the Respect for Marriage Act, a state could go back and say, well, we're no longer granting marriage licenses for same-sex couples. Just they couldn't nullify the ones that already exist. And they couldn't prevent people coming from other states who are already married. So we'd have this weird patchwork of law system. But what it also did was it at the same time said that the 14th and First Amendments erected free exercise rights for folks who dissented from it. So it did both. The reason it passed on such a broad basis was it provided conscience rights for dissenters for gay marriage, and at the same time provided some security for gay marriage, even if the court overturned it. So quite a compromise, but you're right, a compromise that probably never would have happened had there not been Obergefell in the first place to sort of force people into that situation.
But let's talk about why Obergefell or Dobbs v. Jackson, really opposite decisions here, are so controversial, or why they feel so controversial. And it's because of the aristocratic nature of the Supreme Court. These are unelected, life-tenured 9 individuals, these gods on Mount Olympus, who are making big decisions about what the Supreme Court does, or about what the Constitution does or does not say, often contrary to, or sometimes contrary to, prevailing public opinion. Even when Congress hasn't said something about this, there's something about that can feel deeply undemocratic. And it goes back to that Jefferson thing. Which is the popular will? Is it the Constitution as interpreted by these 9 folks? And that's the key. It's as interpreted by these 9 folks who are elite in every way. Or is it the prevailing opinion of the masses as represented in Congress? And I think that's the heart of why people are so bothered by the Supreme Court. It's not even, it's their aristocratic nature.
Yeah, this is hotly disputed whether that's really a problem or not, because there are folks who argue the court actually doesn't do that much that's contrary to national public opinion. What the court quite frequently does is take something that's a matter of dispute and variation across the country, where you have outlier states that don't want to sort of go along with what the rest of the country does. And federalism would normally let you have that variety. And most often judicial review is exercised, when we think of it in controversial versions, to pull those outlier states into conformity with the rest of the country. So judicial review is a kind of tool of national majorities to discipline and create uniformity with states that want to stay out of the prevailing direction in the country. So if that's true, it's not clear if it's a democratic problem or if it's a problem for federalism. So it might be a tool of national democracy, actually, in that telling. Somebody like Mark Graber actually kind of argues with this. That's, he thinks it's a bit of a fiction that the court's anti-democratic. He actually thinks, because of the way we appoint Supreme Court justices, because there's such acrimonious appointment processes and so forth, and over time you've got 9 of them, they were appointed by different people. Supreme Court justices as a whole tend to be far more moderate than the parties that they represent.
Oh, interesting.
I mean, if you look at it, Republicans complain about this all the time, right?
Mm-hmm.
The justices, you put people on the court and they sort of betray you, your party platform. Graeber argues this is a feature, not a bug, because what it means is the court spends a lot of time crafting compromises on these acrimonious issues that actually reflect a very moderate settlement that represents a nationally Democratic majority. In that way, what he's describing is they act like a sort of a super legislature that's doing this kind of work, which is wildly controversial and I don't find empirically compelling.
So here's a potential counterpoint to this. One of the keys in a democratic system is deliberation. That's why you have a representative institution, is to deliberate. Does the Supreme Court undermine both the national deliberative process, neighbor to neighbor, and the congressional deliberative process by doing things like nationalizing same-sex marriage or overturning Roe v. Wade? Or Roe v. Wade is the first example, actually, of cutting short this really important abortion debate and just making a decision. And now there is no path for a national deliberation on this issue. It's been cut short by 9 people. Is that actually deeply democratic? Does it undermine the deliberative system? Is it better? Maybe it produces better results. I'm not sure.
Yeah, the response to this is that it's the deliberation we get publicly is not better because the Supreme Court has weighed in. I mean, the argument for it is the most you sort of hear this, the most intelligent conversations and sort of calm civil conversations we have on these deeply divisive issues happens in courtrooms, right? We let the lawyers argue about it and let the judges ask them questions. And then the judges argue amongst themselves and give us well-reasoned sort of written opinions on it. And that's so much more reasonable than what would happen out in the hurly-burly of, public debate. But was it Sheldon Wolin or someone that who wrote the famous article back in the 90s sort of disputing this? There's a famous essay on deliberation democracy that points out, but it actually hasn't made the public debate on abortion, for example, more reasonable or more deliberative. In fact, we're all arguing over what the 14th Amendment means.
Right.
And the role of judges instead of arguing over what's at issue, which is what's the status of this being growing in the womb? Does it deserve legal protection? And what is the power of its mother over its life?
Right.
Those are fundamental moral and policy issues that the law needs to settle, but we don't argue over that. Instead, we argue over sort of the fine points of substantive due process and how to enforce the 14th Amendment, which are all sort of secondary legal issues instead of talking about the primary policy question. That's a species or like an example of how the court wading in can actually sort of hyper-legalize our debate over things and leave us arguing over legal technicalities and interpretive methods. Living constitutionalism versus originalism instead of arguing over what's important. So, there's a pretty strong case that the court's undermining democratic deliberation.
And it's hard to pinpoint the cases where the court should stay out of it and allow public deliberation and the cases where the court should, in fact, weigh in.
Yeah, when should they stay out? They should stay out. They should weigh in when the Constitution demands an outcome, and they should stay out when it doesn't.
And that's a very hard thing to figure out what that means.
So now we're back to arguing over what the Constitution means.
That's right. Brings us back to what we said at the beginning, which is we're only going to talk about one check, one weapon that the Supreme Court has against the other two branches. And it's because it is their chief weapon. And it is what makes them both a co-equal and fantastically powerful branch of government, and also is their greatest danger to that institution because it exposes them to sometimes democratic ire, to a lot of political controversy, drags them into maybe political debates they didn't intend to be in, and sometimes death threats if you're Brett Kavanaugh. So it's judicial review is everything that the Supreme Court hinges on, both good and bad. But
you could also argue, it's the framers of the Constitution drug the judges into this.
Yeah.
In order to make sure states didn't violate the Constitution, they wrote a Supremacy Clause and said, state judges should do this, should make sure states don't violate the Constitution. So they threw it into the judicial process. And then they wrote in Article 2 that the judicial power extends to cases arising under this Constitution, which wasn't originally there. Originally it says the judicial power shall extend to cases arising under the laws of the United States.
Right.
And then they added the Constitution, and then they had a little debate about, is it a good idea to give the judges a role deciding constitutional meaning? The biggest dissenter from this actually was James Madison. Madison thought judges would not be up to the task of deciding these momentous constitutional questions, because constitutional questions are the most important political questions in our political order. And so Madison thought you actually need political institutions to do some of this. And so instead, he suggested, if you want to make sure states don't do unconstitutional stuff, make the states send their laws to Congress first, and then Congress can veto any state law they think is unconstitutional. That was Madison's solution he proposed at the convention. And then he actually said, instead of having the Supreme Court decide whether federal laws are unconstitutional or not, or just having the president veto them, let's put them together. Let's take the president and the judges and put them on a council of revision together.
Right.
And Congress will send their laws to them, and they'll sit as like a little miniature third body of the legislature that can look at the law, revise it if they think it needs revision, and send it back over to the legislature. Madison thought you should get the judges involved there so that they can actually be involved in the making of laws up front and improve them. But of course, people in the convention objected and said, yeah, but the question of the constitutionality of laws is going to come before the judges in their judicial capacity already. So they said, well, we got judicial review. Why do we need to get the judges involved in the veto? And Madison all throughout thought, judges are not strong enough to do this job. You're asking courts to do a thing that they're not really up to doing. They're not very well constituted to settle constitutional questions for the polity. And so you need to get political institutions to try to answer those questions. And we picked judicial review instead of the political institutions. And the rest of the world has largely followed us, by the way. In the 20th century, for a long time, people thought, that's crazy. Americans let judges decide these questions. And then eventually, with the explosion of written constitutions in the 20th century, the rest of the world went, yeah, I got to enforce them somehow. I guess courts.
But this will be perpetually controversial. Yeah. And it's something that will consistently test, as Madison would say, the power, the integrity of the court to handle these big constitutional questions. Yep. So did we make the right choice between judicial review and the political selection?
I actually think it works quite well. I know this has sounded all very critical throughout, but I think the system of constitutional law has worked fairly well. Obviously, the court makes mistakes at times. I think we've corrected a fair number of those through constitutional amendment, and the court corrects itself from time to time. And I also think, and we didn't really get around to this, that the judges are not really final. I mean, when they've really tried to run crossways of the public's judgment, the political branches find ways, the capacity of the court to really follow through on that. So
judicial review is a supreme power, but not a final power.
Yeah, I think that's a good way to put it. It's just like the president's power to wage war is supreme as commander-in-chief. Nobody else can go command the armed forces. On the other hand, it's also not final. There are ways to put a stop to it, which occasionally happens. So I think...
And by the way, I think that is the core theme of this checks and balances season, is that none of these powers are final. The other two branches, and ultimately the people, always have a say.
Yeah.